Hello everyone. In this series of presentations, an attempt would be made to give an idea of the provisions in Part 1 of the Indian Evidence Act, that is from sections 1 to 55 of the Act. The scope and importance of the law of evidence has already been explained in Part 12 of the Introduction to Laws, which is my first series of presentations on law, and you can refresh your memory by viewing the presentation before starting this series on Indian Evidence Act. The Indian Evidence Act consists of 167 sections and it is divided into three parts. The first part consists of two chapters. Chapter 1, which is preliminary, consists of four sections. Section 1 deals with title, extent, and jurisdiction. Section 2 is repealed. Section 3 deals with the interpretation of several terms used in the Act, and Section 4 deals with presumptions of fact and law. Chapter 2, consisting of sections 5 to 55, deals with relevancy of facts. Part 2 consists of chapters 3 to 6, dealing with the mode of proof. Part 3 consists of chapters 7 to 11, and they deal with the rules regarding the production and effect of evidence. The Indian Evidence Act lays down rules pertaining to the manner in which evidence has to be adduced in civil and criminal proceedings. The Act came into force on 1st September 1872. Its territorial application extends to the whole of India. The Act applies to all judicial proceedings before any court, including court-martial. The Act is not applicable to affidavits or proceedings before an arbitrator. Now, what is a judicial proceedings? The Act does not define the term judicial proceedings. However, there are three tests that are commonly applied to determine whether a proceeding is judicial or not. One is the objective test, wherein the proceedings would be judicial if the object of it is to determine the legal rights and obligations between two parties. Two is the functional test. A proceeding would be judicial if in the course of it evidence is or may be legally taken on oath. The third one is the approach or process test, where the decision making process involves the application of judicial mind or judicial discretion, which is guided by the evidence adduced by both the parties. These tests have to be applied to determine whether a proceeding is judicial or not. The Evidence Act does not apply to proceedings before an administrative tribunal, departmental proceedings, or proceedings before commissions of inquiry. It is also not applicable to the arbitration proceedings. The Act, however, applies to proceedings relating to election offences and to proceedings before the native court-martials and not to proceedings before foreign court-martials. The Act also does not apply to affidavits presented to any court or officer. Now, what is an affidavit? Affidavit is a sworn statement made by a person as to the truth of the facts within his knowledge mentioned therein. So, the Evidence Act would not apply to affidavits presented to court or officer. Section 3 of the Evidence Act is the interpretation clause containing important definitions of terms used in the Act. The term court is defined as including all judges and magistrates and all persons who are legally authorized to take evidence, and specifically excludes the arbitrator from the purview of the definition. The term fact is defined as including any thing, state of things, or relation of things that can be perceived by the senses and any mental condition of which the person is conscious. The first part of the definition covers physical facts, while the second part covers the psychological facts. All facts that can be perceived by bodily senses are physical facts. All facts which are subject of consciousness are psychological facts. The intention of a particular individual in doing an act is a psychological fact. Physical facts are capable of rendering a direct proof, whereas psychological facts are incapable of rendering direct proof. The term relevant is defined as the connection between two facts in any of the ways referred to in the provisions relating to relevancy of facts in section 5 to 55 of the Evidence Act. Now, what is relevancy? Relevancy means connection between one fact and another fact. Relevancy may be logical relevancy or legal relevancy. A fact is said to be logically relevant when, by virtue of application of logic, it appears that one fact has an effect on the other fact. But all logically relevant facts are not provable. A fact is said to be legally relevant when it is expressly declared as relevant under the provisions of the chapter on relevancy from sections 5 to 55 of the Act. For example, A is tried for murder of B by administering poison. The fact that A was to inherit the property of B is the motive which is relevant under section 8. The fact that he procured poison from a druggist shows that he made preparation for committing the offense, again relevant under section 8. The fact that he subsequently confessed of administering poison is relevant under section 24. The fact that B shortly before his death made a dying declaration holding A responsible is relevant under section 32(1). The fact that post-mortem was conducted and expert opinion was given by the doctor that the death was caused by administering a particular poison is relevant under section 45. All these facts are legally relevant under the provisions of relevancy chapter. The term facts in issue means facts which are in issue and form the subject matter of the court's decision. In every legal proceedings, whether civil or criminal, there will be two contesting parties, the plaintiff and the defendant in civil cases, and the prosecution and the accused in criminal cases. That is the reason why it is called an adversarial system. In a suit or proceedings, the plaintiff or the prosecution alleges certain facts as against the defendants or the accused as the case may be, and the defendant or the accused denies them. All these facts which prove or disprove the allegations made by the parties against each other are facts in issue or facts in question. A is accused of causing the death of B. The fact that A intended to cause the death of B, that A was subjected to grave and sudden provocation by B, or that A at the time of committing the act was incapable of knowing its nature due to unsoundness of mind, may be facts in issue as they prove or disprove the accusation against A. Now, the term document, according to section 3, means and includes matters expressed or described on all material substances by means of letters, figures, or marks. Hence, maps, plans, inscriptions on stone or metal are all documents for the purpose of the Act. The term next defined is evidence, which is derived from the Latin root evidere, which means to show clearly, to ascertain, or to prove. The word evidence is used in three different senses generally: as equivalent to relevant, as equivalent to proof, and as equivalent to the material on the basis of which courts come to a conclusion about the existence or non-existence of disputed facts. Where the accused was present near the scene of offense, it is evidence that he may be guilty, but where he was present after the offense was committed, it is not evidence of the guilt of the accused. Here, evidence is used as equivalent to relevant. Where a person possesses stolen property immediately after theft, it is evidence of the fact that the person has committed theft or has received stolen property. Here, evidence is used as equivalent to proof. But the Act uses the word in the third sense, that is, as equivalent to material placed before the court, and on the basis of this material, the court comes to a conclusion as to the existence or non-existence of a disputed fact. The word evidence, as defined in section 3 of the Evidence Act, signifies only the instruments by means of which relevant facts are brought before the court. The instruments adopted for this purpose are witnesses and documents. The definition is only inclusive and not exhaustive. It includes only oral and documentary evidence but does not include material or real evidence, that is, evidence that refers to things like knives, pistols, etc., adduced in evidence. Oral evidence consists of statements made in a court of law by witnesses. A witness is a person who is called upon to give evidence in a court of law. Oral evidence may be direct or hearsay. Now, direct evidence is the evidence of a witness relating to any matter of fact which the witness has himself perceived. Hearsay evidence signifies the evidence heard and said. The law prefers direct evidence as a rule and rejects hearsay. Oral evidence may be direct or circumstantial. Direct evidence establishes a fact and issue. Circumstantial evidence is the testimony by witnesses of circumstances, and sometimes it is referred to as presumptive evidence. It establishes relevant facts. For example, A is charged with murder of B. C, D, E, F, G, and H are witnesses called by the prosecution. C says he saw A stab B. D says he heard B cry out that A was stabbing him. E says that he saw A running away with a blood-stained knife. F says that he saw A washing his blood-stained clothes. G, a doctor, says that the knife found in A's possession might have caused the wounds found on B. H says that he heard from C that he saw A stabbing B. Here, evidence given by C is direct evidence, and that given by others is circumstantial because C gives evidence of the very matter of controversy, whereas the others give evidence of circumstances which, if believed, would assist the court in drawing an inference about the matter in controversy. Circumstantial evidence is as important as the direct evidence, but unlike direct evidence, circumstantial evidence requires logical, cogent, and sequential arrangement of the facts and their proper interpretation. Evidence can be substantial or corroborative. When evidence is given of the fact in issue or of a relevant fact, it is called substantive evidence. There may be several statements which are oral or documentary, which are not substantive evidence. They are not admissible by themselves but become admissible to corroborate or support substantive evidence already given. Thus, corroborative evidence must be taken along with substantive evidence. Now, documentary evidence means and includes all documents produced before the court for its inspection. Documentary evidence may again be primary or secondary. Primary evidence is the very document itself produced before the court for its inspection. In the absence of such primary evidence, the next best evidence, that is the secondary evidence, can be permitted after accounting for the non-production of the primary evidence. So that is giving reasons as to why the primary evidence could not be produced. Material or real evidence means material objects like knives, guns, etc. adduced as evidence. The idea of best evidence is implicit in the Act. Evidence under the Act consists of statements made by the witnesses or contained in a document. If it is a case of oral evidence, the Act requires that only the persons who actually perceive something by their senses or by that sense by which it is capable of perception should make the statement about it and no one else. If it is documentary evidence, the Act requires that ordinarily the original should be produced because a copy may contain omissions or mistakes of a deliberate or accidental nature. The term proof is not defined in Indian Evidence Act, but the term proved, disproved, and not proved are defined in section 3. A fact is said to be proved if the court, after considering matters before it, believes it to exist or considers its existence probable as per the standard of a prudent man. A fact is said to be disproved if the court, after considering matters before it, believes it does not exist or considers its non-existence probable as per the standard of a prudent man. A fact is not proved when the fact is neither proved nor disproved. A court, after considering the evidence adduced before it and hearing arguments, comes to a conclusion as to the existence or non-existence of various facts asserted or denied by the parties, and after finding all the facts, applies the rule of law. If all the facts stated in the rule of law are found to exist, the right or liability which would follow according to the rule of law is decreed or ordered by the court. Where a court finds that facts exist, the facts are said to be proved. If the court finds that they do not exist, they are said to be disproved. When the fact is neither proved nor disproved, it is said to be not proved. Thus, proof is a mental process by which one arrives at a conclusion that a fact exists or does not exist on the basis of evidence. Presumptions. A presumption is an inference drawn by the court as to the truth of a particular fact from other known or proved facts. Presumptions may be presumption of fact or natural presumptions, and presumptions of law or artificial presumptions. Presumptions of fact are those which our mind logically draws without the aid or directions of law. They are the presumptions which are drawn spontaneously by operation of our reasoning faculty. Presumptions of law derive their force from law and apply to a class the conditions of which are fixed and uniform. Presumptions may be rebuttable or irrebuttable. A presumption is rebuttable if the law permits the party against whom the presumption is drawn to disprove it. It is irrebuttable if the law does not permit the party to disprove it. Presumption of fact are always rebuttable, but presumption of law are sometimes rebuttable and sometimes irrebuttable. Section 4 of the Evidence Act defines 3 kinds of presumption. Whenever it is provided by the Evidence Act that the court may presume a fact, it has the discretion either to presume that fact and regard it as proved until it is disproved, or refuse to presume the fact and call for the proof of it. For example, under Section 114 of the Evidence Act, the court may presume that a man who is found in possession of stolen goods soon after the theft is either a thief or has received such goods with the knowledge that it is stolen, or the court may refuse to presume the guilt of the accused and ask the prosecution to prove the guilt, as the power here is discretionary. Whenever it is directed by the Evidence Act that the court shall presume a fact, it shall regard such fact as proved unless and until it is disproved. Section 113b is an example. When the question arises whether a person has caused the dowry death of a woman, if it is shown that prior to her death, she had been subjected to cruelty by such person for or in connection with the dowry demand, the court shall raise a presumption against the person that he caused the dowry death, and it is upon the accused to rebut this presumption by adducing evidence. When one fact is declared by the Evidence Act to be conclusive proof of another, the court shall, on proof of that fact, regard the other as proved and shall not allow evidence to be given for the purpose of disproving it. For example, there the question is whether A and B are husband and wife, and when a divorce decree is produced, the court shall conclusively presume that they are no longer husband and wife from the date of such divorce decree. The court shall not permit any kind of evidence for the purpose of disproving the fact that they cease to be husband and wife from the date of the divorce decree. The divorce decree is regarded as conclusive proof of the fact that marital tie between them is snapped. This, in brief, is about the preliminary aspects of the Evidence Act. Thank you.